I have heard defendants say many foolish things from the other side of my bench. I have heard them deny signed contracts. I have heard them insult witnesses. I have heard them laugh while evidence slowly destroyed their story. But the day Karen Parker leaned across the courtroom table, smiled at me, and said, "You can't touch me," I remember feeling the entire room hold its breath, because people like Karen do not usually say those words unless someone has taught them they are true. And what happened after that made her realize she had walked into the one room where her last name, her money, and her connections meant absolutely nothing. Before we go any further, make sure you have subscribed to this channel for more powerful courtroom stories like this one. And if you haven't subscribed yet, do it now. Also, comment below and tell us where you are watching this video from. Now let me take you back to where this case truly began. The plaintiff was a man named Thomas Reed, 49 years old. Small business owner, soft voice, clean shirt, tired eyes, the kind of man who looked as if life had already taken enough from him before he ever stepped into my courtroom. He owned a family-run auto repair shop outside Cleveland. Nothing glamorous, nothing flashy. Just a modest garage his father had opened 30 years earlier, with 3 employees, 2 service bays, and a hand-painted sign that had survived more winters than some of the cars parked under it. Across from him sat Karen Parker, 36 years old, polished, composed. Expensive coat folded neatly over her chair, Distan sunglasses resting on the table beside her paperwork. She looked less like a defendant and more like a woman waiting for an inconvenience to end. That is something I notice immediately. People who respect the court sit differently. People who fear consequences sit differently. And people who believe consequences are beneath them, they have a stillness that is almost theatrical. Karen had that stillness. Her case appeared simple at first. Thomas claimed Karen owed him $12,800 for repairs on a luxury SUV. According to his complaint, Karen had brought the vehicle to his shop after a collision, damaged the front suspension, radiator support, bumper assembly, and several internal components. She approved the estimate. She signed the work order. She picked up the vehicle. Then she reversed the payment. Karen claimed the work was defective. Thomas claimed the vehicle was repaired properly and that Karen had never complained until after the bank dispute was filed, a normal civil matter. At least, that is what I thought when the case began. Then Karen opened her mouth. I asked Thomas to explain what happened. He stood carefully, holding a folder with both hands. Your Honor, Miss Parker brought the car in on March 14th. We inspected it, sent her the estimate, and she approved it in writing. Karen interrupted immediately. That is not what happened. I looked at her. Miss Parker, you will have a turn. But he is already lying. You will have a turn. She leaned back and smiled as if I had amused her. That smile stayed with me, not because it was pleasant, because it was empty. Thomas continued. He explained the parts ordered, the labor performed, the diagnostic testing, the final inspection, and the payment. He placed invoices, photographs, signed approvals, and text messages into evidence. Everything was organized, everything had dates, everything had signatures. People often underestimate organized evidence. They think drama wins courtrooms. It does not. Documents do. Karen watched him with a faint smirk, tapping one manicured finger against the table. Tap, tap, tap. A small sound. But in a courtroom, small sounds can become loud. I asked Thomas whether Karen inspected the vehicle when she picked it up. Yes, Your Honor. She walked around it twice. She said it looked perfect. Karen laughed, not loudly. Just enough for everyone to hear. I turned to her. Something funny. She crossed her arms. He likes saying things that make him sound professional, and you will have the opportunity to challenge those things with evidence. I have evidence. Good. Then wait your turn. Her face hardened slightly. There it was, the first crack. People like Karen are comfortable when they are speaking. They become uncomfortable when they are forced to listen. Thomas handed me a printed text exchange. I read it silently, then again. Then a third time, because the words were clear. The day Karen picked up the SUV, she texted Thomas, "The car looks great. Thanks for rushing it." I looked up. "Ms. Parker, did you send this message?" She hesitated, only a moment. "Yes, but that was before I realized what they did." "What did they do?" "They messed up the car." "How?" The whole thing felt wrong. That answer concerned me. Not because cars cannot feel wrong, they can, but vague complaints often appear when specific proof does not exist. "What exactly felt wrong?" I asked. Karen waved one hand as though the question bored her. The steering, the noise, the way it drove, everything. "Did you take it to another mechanic?" "Yes." "Do you have a report?" She paused. "No." "Do you have photographs?" "No." "An invoice from the second mechanic?" "No." "Any written complaint to Mr. Reed before reversing the payment?" Karen looked away. "No." The courtroom became quiet. Thomas did not smile. He did not look triumphant. He just looked tired. That told me something about him. He had not come to embarrass her. He had come to be paid. There is a difference. I turned back to Karen. "You reversed a payment of $12,800 without giving the repair shop an opportunity to inspect the vehicle." She lifted her chin. "I did what I had to do." That phrase always interests me. I did what I had to do. People say it when they want necessity to replace a responsibility. But responsibility does not disappear because someone uses confident language. I reviewed the bank dispute documents. Karen had claimed the charge was unauthorized, not defective, unauthorized. That was different, very different. "Ms. Parker," I said, "you told your bank you did not authorize this charge." "I did not authorize bad work. That is not what unauthorized means." She stared at me. I continued. "You signed the estimate. You signed the work order. You sent a text thanking him for the repair. Then you told your bank the charge was unauthorized." Karen's tapping stopped. The room felt it. So did I. That was the moment the case shifted, because now we were no longer discussing dissatisfaction. We were discussing misrepresentation. Karen leaned forward, her voice low but sharp. "You do not understand who you are dealing with." Several spectators shifted in their seats. Thomas looked down. I looked directly at her. "Then explain it to me." She smiled again. That same empty smile. "My family knows people." There it was. Not evidence, not law, not facts. Power, at least what she believed was power. Years on the bench teach you that some defendants come prepared with documents. Others come prepared with intimidation. Karen had brought intimidation, and she was about to learn that it did not work here. "Mrs. Parker," I said, "this is a courtroom, not a country club." Her smile vanished. Then she leaned closer to the table, and in a voice quiet enough to sound controlled, but loud enough for every person in that room to hear, she said, "You can't touch me." The room froze. Thomas slowly raised his head. The court officer looked toward me. Even the spectators stopped moving. Karen sat back as if she had just ended the case with one sentence, but she had not ended anything. She had only opened a door, because the moment she said those words, I noticed something disturbing in Thomas Reed's file. A second bank dispute, then a third, then a fourth, all connected to Karen Parker, all involving different businesses, all using the same phrase, authorized charge. I looked at Karen, and for the first time that morning, her confidence began to fade, because she realized I had seen the pattern. The moment I noticed the pattern, I stopped looking at Karen. That may sound strange, but years on the bench teach you that some of the most revealing moments occur when a person believes you are no longer paying attention to them. I shifted my focus to the documents. Karen watched me carefully, very carefully. The confidence she displayed moments earlier had not disappeared, but it had changed. Before it looked effortless. Now it looked calculated. There is a difference. People become calculated when they sense danger. I reviewed the bank records again. 4 separate disputes, 4 separate businesses. 4 separate claims of unauthorized charges. Interesting, very interesting. The dates stretched across nearly 18 months. Different industries, different services, different vendors. Yet the language appeared almost identical. That bothered me, because coincidence rarely writes with the same handwriting. I looked toward Karen. Ms. Parker, yes? Have you previously disputed charges with other businesses? Her expression remained calm, too calm. No, lie, and she knew it, because the documents were already sitting in front of me. That response immediately caught my attention, not because people never lie in court. Unfortunately, they do, but because she lied about something that was easily verifiable. That usually means one of 2 things. Either the person panicked, or they have spent so much time getting away with dishonesty that they no longer expect anyone to challenge it. Karen felt like the second category. I held up the records. These disputes belong to you, correct? The confidence disappeared for a fraction of a second, then returned, yes. Then why did you just say no? Silence not long, but noticeable. I thought you meant something else. Interesting answer, the kind of answer that technically responds while avoiding the question. People often mistake that strategy for intelligence. Judges do not, I continued. One dispute involved a custom furniture company. Another involved a private contractor. A third involved a landscaping business. Each claim followed the same sequence: Durf performed, approval given, payment processed, dispute filed, money recovered. I looked at Karen. You claimed all of these charges were unauthorized? Yes. Did you authorize any of them? They were bad services. That is not what I asked. The courtroom became quiet. Karen folded her arms. Again, that gesture was becoming familiar. Every time evidence cornered her, the arms crossed psychologically. People often create physical barriers when they feel vulnerable. Karen was creating one now. I turned toward Thomas. Were you aware of these previous disputes? He shook his head. No, Your Honor. His voice carried genuine surprise, not performative surprise, real surprise. I believed him. That observation mattered because innocent people often react differently when new information appears. Thomas looked confused. Karen looked worried. That difference stayed with me. I continued reviewing documents. Then I found something even more interesting. The furniture company had submitted photographs. The landscaping company submitted emails. The contractor submitted text messages. And every single file contained the same pattern. Karen praising the work before disputing the charge. Praise first, dispute later. Again and again and again. The repetition was becoming impossible to ignore. I looked up. Ms. Parker, why do you repeatedly compliment services before claiming they were unauthorized? Karen immediately interrupted. Because I was being polite. Polite? Yes, interesting, very interesting, because politeness usually does not involve reversing thousands of dollars in charges afterward. I noticed several spectators exchanging looks. They were seeing the same contradictions. So was Karen. That was why her answers were becoming shorter. The more evidence appeared, the less she wanted to explain. Then I found an email, a simple email. Only 2 sentences, yet it changed the atmosphere immediately. I read it silently, then again, then a third time. Because I wanted to be certain. I looked toward Karen. The moment she saw which document I was holding, her posture changed instantly. That reaction alone told me the email mattered. Did you send this? A pause. Yes. The room remained silent. I began reading. The easiest way to handle vendors is to challenge the charge after delivery. Most businesses won't fight it. Nobody moved. Nobody spoke. Even Karen remained silent because she could not. The words belonged to her, not to Thomas, not to another witness. To her. I watched the spectators. Several looked stunned. Thomas stared at the table. And suddenly I understood why. This case had never really been about a car repair bill. The repair bill was merely the latest chapter. The pattern was much larger, much older, much more deliberate. Karen sensed it too. That was when she stopped trying to defend the repair dispute. Instead, she started attacking the process. Another common strategy. When facts become dangerous, attack the system evaluating them. This is ridiculous. Those emails don't prove anything. You don't have the full context. Over and over. The objections became faster, more emotional, more desperate. That caught my attention. Because until then, Karen had appeared emotionally controlled. Now the control was slipping. And people reveal themselves when control slips. Then she made a mistake, a serious mistake. She looked directly at me and smiled, not confidently, defensively. And she said something I will never forget. You already decided I'm guilty. Interesting choice of words. Not liable, not responsible. Guilty, the language mattered. Because nobody had accused her of a crime, at least not yet. I leaned back, Miss Parker. This is a civil proceeding. She realized the mistake immediately. I saw it, a flash of panic. Gone almost instantly, but not fast enough. Years of courtroom experience teach you to notice those moments, the moments when someone's mind arrives somewhere before their mouth should have taken it. Karen had accidentally revealed her own fear, and fear is informative, very informative. Then something happened that completely changed the direction of the case. The court clerk quietly approached my bench. She handed me a newly received document packet. I reviewed the first page, then the second, then the third. And suddenly the repair dispute seemed much less important because the records in front of me showed that one of the businesses Karen disputed 18 months earlier had filed a private fraud complaint. A complaint that had been quietly investigated. A complaint that mentioned several names, several transactions, and one familiar phrase, unauthorized charge. I slowly looked up. Karen was staring directly at me. The color had completely disappeared from her face because somehow she already knew exactly what was inside that file. The moment I looked up from the file, Karen Parker stopped blinking. That may sound like a small detail. It wasn't. Years on the bench teach you to watch what people do when they are afraid. Some become louder, some become emotional. Some become aggressive. Karen became still, very still. And stillness can be more revealing than panic, because panic is often spontaneous. Stillness is often calculation. She was thinking, trying to determine how much I knew, trying to determine what was inside that file, or perhaps trying to determine how much of it could still be explained away. I remember looking around the courtroom. Thomas Reed sat quietly beside his stack of invoices. The spectators were watching carefully. The court officer stood near the wall, and Karen looked like a person waiting for a storm to arrive. The problem was, the storm had already arrived. She just hadn't seen all of it yet. I opened the file again. The complaint originated from a furniture company in Chicago. A company Karen had hired nearly 2 years earlier. According to the records, she ordered custom pieces worth almost $27,000. The furniture was delivered. The installation was completed. Karen signed the delivery confirmation. Then she disputed the charge. Sound familiar? It should, because it was almost identical to the story Thomas had just described. But that wasn't what caught my attention. What caught my attention was what happened afterward. The furniture company hired a private investigator. And that investigator discovered something interesting. Very interesting. I looked toward Karen. Did you tell the furniture company the items were never delivered? She hesitated, then nodded. Yes. Were they delivered? Silence. The spectators leaned forward. Karen folded her arms. Agan then finally said, I don't remember. Interesting. People often forget facts that become inconvenient. Yet they somehow remember facts that help them. Years of courtroom experience have made me skeptical of selective memory. I turned back to the file. The investigator photographed the furniture inside Karen's home. Every piece, every chair, every table, every custom cabinet still being used months after the charge dispute succeeded. That observation bothered me. Not legally, psychologically, because it suggested something deeper than a disagreement. Most dissatisfied customers want repairs, funds, corrections, solutions. Karen appeared to want something else, the service. Without the payment, I continued reading. Then I found another report, different company, different state, same Stattern, a landscaping contractor. Karen approved the project, praised the work, hosted a garden party 2 weeks later, then disputed the payment again and again and again. Every page reinforced the same conclusion. The business has changed. The method did not. That is when I noticed something disturbing. Karen never looked at Thomas, not once, not during the evidence, not during the testimony. Not during the discussion. She looked at me. She looked at the documents. She looked at the spectators, but never Thomas. Years on the bench teach you that eye contact often reveals emotional priorities. People who feel guilty frequently avoid the person they harmed, not always, but often. And Karen seemed determined not to acknowledge Thomas at all, as if looking at him would force her to recognize something she preferred not to see. Then I discovered the document that changed everything, a printed email exchange. The sender name had been partially redacted, but Karen's email address remained visible. I read it once, then twice, then a third time because the language was extraordinary. I looked toward Karen. She immediately knew. Her breathing changed. A tiny shift, but I noticed. Did you write this? Silence. Miss Parker? Another silence. Then yes, the courtroom became completely still. I began reading. Most small businesses are too scared to challenge chargebacks. Nobody moved. I continued. The banks almost always side with the customer silence. Then the next sentence. The sentence that made even me pause. Once they lose the money, they usually give up. Thomas lowered his eyes. The spectators exchanged shocked looks. Karen stared at the table because there it was. Not frustration, not misunderstanding, strategy, documented strategy. People often imagine dishonesty is emotional, impulsive. Chaotic, the most dangerous dishonesty is planned, methodical, potted. And Karen appeared to be exactly that. I remember thinking something at that moment. This woman didn't believe she was stealing. She believed she was smarter. That distinction matters. Because people who see themselves as criminals usually hide. People who see themselves as smarter than everyone else become careless. And careless people leave records. Karen left plenty. Then she made another mistake, a major one. She finally looked at Thomas for the first time all day, and what she said sent a chill through the courtroom. Businesses fail every day. The room froze. Thomas looked at her. She continued, if his shop can't survive one dispute, that's his problem. I remember the silence that followed, not because the statement was loud, because it revealed so much. Karen wasn't arguing about repairs anymore. She wasn't arguing about invoices. She was revealing how she viewed people. Businesses weren't families. Employees weren't individuals. consequences weren't personal. Everything was transactional. And that mindset explained everything. Then I noticed something in the fraud complaint file, a name, a second name, then a third. The same names appeared repeatedly across multiple investigations, different businesses, different complaints. Same individuals reviewing the chargeback disputes. Interesting, very interesting. I read further, and suddenly a new possibility emerged, one that I had not considered before. What if Karen wasn't acting alone? The thought disturbed me because repeated behavior can indicate a pattern, but repeated success can indicate assistance. I reviewed the documents again. The names kept appearing over and over. Then I found a handwritten note attached to one report, a note from an investigator. Only one sentence, but it changed everything. I slowly looked up. Karen saw my expression, and for the first time that day, she looked genuinely frightened, because the note suggested federal investigators were no longer examining chargebacks. They were examining a network, and according to the investigator, Karen Parker's name was at the center of it. I remember the exact moment Karen Parker realized this was no longer just a dispute over a repaired SUV. It happened when I closed the file, not slammed it, not dramatically, just closed it, quietly. Because sometimes the quiet moments carry the most weight. Karen watched every movement, every page, every expression. She had spent the entire hearing trying to predict the direction of the case. Now she couldn't. And uncertainty frightened her. Years on the bench teach you something important. Confident people can tolerate uncertainty. Manipulative people often cannot, because manipulation depends on control. And Karen was losing control fast. The courtroom remained silent. Thomas Reed looked confused. The spectators looked curious. Karen looked worried, very worried. I reviewed the investigator's note again. The language was careful, professional, measured, but the implication was unmistakable. Several complaints across multiple states shared the same characteristics, the same chargeback methods, the same approval patterns, the same dispute language, and somehow the same people repeatedly appeared during review stages. That was not proof, not yet.
Yeah.
But it was enough to raise questions, serious questions. I looked toward Karen. Have you ever met a man named Gregory Wallace? The reaction was immediate, too immediate. Her eyes widened, only briefly. Then she recovered, but not fast enough, I noticed. Years of courtroom experience make those reactions difficult to hide. No. Lie. Not because I had already proven it, because her body had answered before her mouth did. Interesting. Very interesting. I held up an email. Would seeing a photograph help refresh your memory? Karen remained silent. I placed the photograph on the evidence monitor. The image showed a charity event, a fundraiser. Nothing unusual at first glance. Then I pointed toward two people standing together. Karen Parker, Gregory Wallace, smiling for the camera. The spectators immediately reacted. Karen looked away. That told me plenty. Would you like to revise your answer? A long pause followed. Then, I met him once. Interesting. Moments earlier, she claimed she never met him. Now she had. The truth was slowly forcing its way into the room, and Karen knew it. I continued reviewing the records. Gregory Wallace worked for a third-party financial review contractor. His name appeared in multiple chargeback investigations connected to Karen, again and again. The same name, the same reviewer, the same outcomes. I wasn't accusing anyone of misconduct, not yet. But the pattern existed, and patterns deserve attention, especially when money follows them. Then something happened that bothered me, not legally, personally. I found an internal message recovered during the earlier fraud inquiry. The message contained a list of businesses. Most were small companies. To family-owned operations, independent contractors, repair shops, landscapers, furniture makers. Nothing enormous, nothing powerful. I studied the list, then I realized something. Karen consistently targeted businesses least capable of surviving lengthy disputes. That observation disturbed me because it suggested calculation. Years on the bench teach you how predators think. Predators rarely attack the strongest target. They attack the easiest target. And Karen's choices suddenly made far more sense. Thomas's repair shop, the furniture company, the landscaping contractor. The pattern was becoming clearer. Then I noticed something else. Every business on the list had one thing in common. None employed in-house legal teams. None had significant corporate backing. None possessed the resources needed for prolonged litigation. Interesting, very interesting. Karen wasn't choosing victims. She was choosing probabilities that people would eventually give up. And according to the records, many had. I looked toward Thomas. Why did you continue pursuing this? He hesitated, then answered, because my father built that shop. The room became quiet, not dramatic, just quiet. Thomas continued. He died 3 years ago. Nobody moved. I couldn't explain to my employees why $12,000 disappeared. I watched Karen. She showed no reaction, not sympathy, not discomfort, nothing. That told me something. People don't need to cry to show empathy, but most people show something. Karen showed nothing. And that absence became increasingly difficult to ignore. Then the court clerk approached my bench again. Another document, another update. I reviewed the first page, then the second, then the third. And suddenly my concern became something else entirely. Because federal investigators had identified additional disputed transactions, dozens, not 4, not 8 dozens, across multiple states. The total value exceeded $600,000. The spectators didn't know that yet. Karen did. I could tell because she was staring directly at the document, not blinking, not moving, just staring. The way people stare at something they already understand. I looked up Ems Parker. No answer. Would you like to explain why your name appears in 32 disputed payment investigations? The room froze. Thomas looked stunned. The spectators exchanged looks. Karen remained silent. Then she finally spoke, quickly, too quietly. That's not what this case is about. Interesting response. Not. That isn't true. Not. There's a mistake. Not. I've never seen those investigations. Instead, that's not what this case is about. Psychologically, that answer fascinated me because it acknowledged the existence of the investigations without challenging them. Karen was adapting poorly, but adapting the problem was that every adaptation revealed something new. Then I discovered the detail that changed everything. A financial transfer, one transfer, small compared to the others, but important, very important. The transfer connected Gregory Wallace to an account controlled by a consulting company, a company partially owned by Karen Parker. I reviewed it again, then again, because if accurate, the implications were enormous. The courtroom remained silent. I looked at Karen. Karen looked at me. And for several seconds, nobody spoke. Then she whispered something, so quietly that only the nearest microphone captured it. But I heard it, and I will never forget it. She said, "You weren't supposed to see that." The room froze. And at that moment, even I struggled to stay composed because Karen had just stopped defending herself. She had started revealing the truth. I have presided over cases involving fraud, theft, deception, and betrayal. But there are moments that stay with a judge forever. Moments when someone accidentally says the one thing they were never supposed to say. Karen Parker's whisper was one of those moments. You weren't supposed to see that. The instant those words left her mouth, the atmosphere inside the courtroom changed, not because the statement was loud, because it was honest. For the first time all day, and honesty, when it arrives unexpectedly, can be far more damaging than a lie. The courtroom remained silent. Thomas Reed stared across the room. The spectators looked confused. Some probably didn't even hear the comment, but I did. And Karen knew I did. I watched her carefully. Years on the bench teach you to recognize regret, not remorse. Regret, Karen regretted saying it. Immediately, her eyes widened, her shoulders stiffened, her breathing changed. She understood exactly what had happened. The mask had slipped. And once a mask slips, people begin wondering what else is underneath it. I leaned forward. Miss Parker. Silence. Would you like to explain what you meant? She looked away. No. Interesting. Very interesting, because innocent people usually rush to explain misunderstood statements. Karen did the opposite. She wanted the statement buried, forgotten, ignored. That told me everything. I returned my attention to the financial records. The transfer was real, verified, documented. And it connected Gregory Wallace, the same reviewer appearing repeatedly in disputed chargeback cases, to a consulting company partially controlled by Karen. The implications were disturbing. Not proof of a crime, not yet, but enough to raise serious questions. Then something happened I did not expect. A federal investigator entered the courtroom, not dramatically, not with flashing badges or loud announcements. Quietly, professionally, the way experienced investigators often move. The room noticed immediately. Karen noticed most of all, because the color disappeared from her face completely. The investigator approached the clerk, spoke briefly, then handed over a sealed packet. I opened it, reviewed the first page, then the second, then the third. And I remember feeling something I rarely feel during a hearing. Shock, real shock. Because suddenly the $12,000 repair bill was the least important thing in the room. The documents contained newly recovered communications, private messages, financial records, account information, and one particular spreadsheet, a spreadsheet that made my stomach turn. I looked toward Karen. She already knew. That was obvious. People react differently to unexpected evidence. Karen wasn't surprised. She was defeated. There is a difference. I placed the spreadsheet onto the evidence monitor. The spectators leaned forward. Thomas looked confused. Then the screen filled with names. Business names, dozens of them, repair shops, landscapers, furniture makers, construction contractors, family-owned businesses, small operations, the exact types of companies least equipped to survive financial disruption. Then another column appeared. Chargeback status. Approved, approved, approved. Approved over and over, page after page. Approved, approved, approved. The room became silent. Then I noticed the final column, Baltiley score. Interesting, very interesting. Each business had been assigned a number, 1 through 5. I studied the pattern. Businesses with weaker financial reserves received higher scores. Businesses with fewer employees received higher scores. Businesses with limited legal resources received higher scores. And then I understood the score wasn't measuring value. It was measuring vulnerability. I remember looking at that screen and realizing something deeply disturbing. Karen hadn't been randomly disputing payments. She had been selecting targets carefully, methodically, intelligently. Thomas wasn't unlucky. He was chosen. The spectators began whispering. The court officer called for silence. Karen sat perfectly still. No interruptions, no objections. No arguments, nothing. Because for the first time in the hearing, there was nothing left to interrupt. The truth was speaking for itself. Then I found the entry that created the viral courtroom moment people would talk about for years. Thomas Reed Auto Repair Bailiti score, 5, recovery probability low, recommended action chargeback.
Whoa.
The courtroom gasps, actually gasped. Thomas looked like he had been punched. I watched him stare at the screen, not angry, not emotional, just stunned, as if he had finally learned that what happened to him was never personal. It was business. Cold, calculated, predatory business. Then I noticed something else, a note attached to Thomas's file. Only one sentence. I read it twice, then a third time, because even after everything else, I could hardly believe it. The note read, "Owner unlikely to pursue litigation." I looked toward Thomas. A man who had spent months fighting for his business. A man sitting in my courtroom because he refused to quit. Someone had reduced him to a probability calculation. And that bothered me more than the money. Then Karen finally spoke. The first words she had offered in nearly 20 minutes. It wasn't supposed to work like this. The room froze. Interesting. Very interesting, because that wasn't a denial. It was an admission. Psychologically, people often confess when they stop believing escape is possible. Karen was reaching that point. I asked a simple question. What wasn't supposed to work like this? Silence. Then another silence. Then she whispered, "Gregory said nobody would ever compare the cases." Thomas slowly turned toward her. The spectators stopped moving. And for one long moment, nobody breathed, because Karen had just connected herself directly to the scheme, not through evidence, not through documents. Through her own words, the federal investigator stood calmly, professionally. Then he delivered the sentence that shattered what remained of Karen's confidence. "Miss Parker, Gregory Wallace was arrested this morning." Karen closed her eyes. The room remained silent. The investigator continued, "And he has already started cooperating." I will never forget what happened next. Karen looked toward me, then toward Thomas, then toward the evidence screen, and suddenly she began crying, not quietly, not strategically, not for sympathy, because for the first time she understood the truth. The man she trusted had already told investigators everything, and the next document waiting inside that sealed packet contained something that would destroy her completely. Something even Karen did not know they had found. I remember the silence more than anything else. Not Karen's tears, not the evidence, not even the federal investigator standing only a few feet away. The silence. Because everyone in that courtroom understood that whatever came next would change everything. Karen Parker sat motionless. Her confidence was gone. Her composure was gone. Even the arrogance that had defined her from the moment she entered the courtroom had vanished. All that remained was fear, real fear. And fear has a way of revealing truths that pride spends years trying to hide. The federal investigator handed me the final document packet. I opened it slowly. The courtroom watched. Thomas watched. Karen watched. I reviewed the first page, then the second, then the third. And I remember feeling something unexpected, disappointment, not because the evidence was shocking, because it confirmed what I had already begun to suspect. Karen had not stumbled into bad decisions. She had built a system around them. The documents contained recovered communications from Gregory Wallace's devices, datums, Moss financial records, spreadsheets, meeting notes. And buried among them was the piece that explained everything, a private memorandum prepared months earlier. The title alone was disturbing. Vendor Recovery Strategy. Interesting, very interesting. Because vendors are businesses, people, families, workers, yet the language treated them like inventory, statistics, variables, targets. I read the document carefully. The strategy was brutally simple. Identify businesses least capable of fighting back, approve services, defect products, delay payment, dispute charges. Pressure vendors into abandoning recovery efforts, move to the next target, Again and again and again. The room remained silent even after years on the bench. I found the coldness difficult to ignore. Not because it was sophisticated, because it was intentional. Every step had been planned, every outcome anticipated. Then I reached the final page, and there it was. The detail that destroyed any remaining defense. A list of participants: Gregory Wallace, several financial consultants, administrative contacts, and one final name, Corin Parker. Not referenced indirectly, not implied, listed directly, with responsibilities assigned beside each name. The spectators gasped. Thomas lowered his head. Karen closed her eyes. The truth had arrived. Completely, irrefutably, I looked toward her. Mrs. Parker, do you dispute this document? A long silence followed, the longest silence of the day. Then she slowly shook her head. No, not a denial. Not an explanation. No, years on the bench teach you that some confessions happen without words. This was one of them. The federal investigator then revealed something even Karen did not expect. Gregory Wallace had provided recordings, private recordings, recorded during planning meetings. Several participants were identified. Karen's voice appeared repeatedly, discussing targets, discussing disputes, discussing financial pressure. The recordings left little room for interpretation. At that point, the courtroom no longer felt like the setting for a civil disagreement. It felt like the final chapter of something much larger. I turned toward Thomas. He looked exhausted. Months of uncertainty, months of stress, months of wondering whether he would ever recover the money his business earned. Now he finally had answers. But answers do not always bring satisfaction. Sometimes they simply bring clarity. And clarity can be painful. I asked him one final question. Why didn't you give up? He looked at me, then at Karen, then back at me. And his answer is something I still remember. Because if she could do it to me, she could do it to somebody else. The room became quiet again. That answer mattered, because Thomas never saw himself as a hero. He never entered court trying to expose a larger scheme. He simply refused to surrender. Yet that refusal changed everything. Corin looked at him for several seconds. The first genuine look she had given him all day. No contempt, no arrogance, no superiority, just regret, and perhaps for the first time, understanding. The federal investigator informed the court that additional proceedings would follow through the appropriate criminal channels. My responsibility remained the civil dispute before me. The evidence was overwhelming. The work had been authorized. The repairs had been completed. The payment reversal was improper. Judgment entered in favor of Thomas Reed, Sybil Clear. Supported by facts, the courtroom remained silent. Thomas closed his eyes briefly. Relief, not celebration. Relief, there is a difference. People imagine justice feels triumphant. Often it feels exhausting, especially when someone has spent months fighting for it. Karen sat quietly, no interruptions, no objections, no speeches. The woman who began the hearing by telling me, "You can't touch me," now understood something important. The court was never trying to touch her. The evidence did. And evidence reaches places arrogance cannot protect. As people began leaving the courtroom, I remained seated for a moment, reflecting, because some cases stay with you, not because of the money involved, not because of the publicity, but because they reveal something fundamental about human nature. Karen believed power meant immunity. She believed intelligence meant manipulation. She believed consequences were obstacles for other people. And for a long time, perhaps those beliefs appeared to work until they didn't. That is the lesson I carried away from that day. Not every dishonest person gets caught immediately. Not every manipulative scheme collapses quickly. But eventually patterns leave traces. Records accumulate. Witnesses speak. Mistakes happen. and the truth begins assembling itself piece by piece. Karen walked into my courtroom convinced nobody could touch her. She left understanding a reality that applies far beyond any courthouse. Money can delay consequences, can complicate consequences. Confidence can disguise consequences, but none of them eliminate consequences. Years later, I still remember the expression on her face when she finally understood that. Not because she lost, because she realized she had never been untouchable. She had simply mistaken silence for safety. And the moment the truth found its voice, everything changed.